All right, guys, it's Raymond DeLeon with Smooth Operation of Law. Let me put this down. Let me sit down. All right, guys. So today what we're going to do is, if you can see the website, all right, info.wealthcounsel.com. This is estate planning for intellectual property. So this is your trademark, copyright, patent, trade secret in a trust. I'm going to start reading and then I'm going to start talking freelancing. Estate planning is widely recognized as a means of transferring wealth from one generation to the next while minimizing both taxes and the risk of loss to creditors. A comprehensive estate plan not only transfers cash investments, real estate, and vehicles, but also less commonly considers assets such as intellectual property. While clients in certain professions, for example, authors, artists, small business owners, and inventors often recognize the needs to protect their valuable intellectual property, every client potentially has intellectual property that could provide a stream of income for family members or loved ones after the clients passed away. Intellectual property refers to works or inventions that are the result of a human creativity and intellect and can be legally protected. Example, by copyrights, patents, trademarks, or trade secrets. Let's stop right there. I want you guys to focus on trademarks and trade secrets. Moving on. Such works and inventions are protected by federal and sometimes state law and can have great commercial value. Accordingly, clients should include intellectual property among the assets they share with their estate planning attorney at the outset of an engagement. In addition to the intellectual property itself, clients should disclose any related agreements, assignments, or licenses. Varying steps are necessary to planning considerations for each can also vary in some respects. Varying steps are necessary to legally protect different types of intellectual property, and the estate planning considerations for each can also vary in some respects. The four primary types of intellectual property are discussed below, along with key planning considerations. Now, I said trademarks and trade secrets. So let's scroll down to that. Trademarks. Protection is available for brand names and logos used to identify and distinguish the goods and services of one source from those of another. Although merely using a trademark without obtaining a trademark registration protects it under common law, this legal protection only extends to the geographic region in which the trademark is used. Now, be advised. I'm going to stop right there because I just caught the fucking Holy Ghost of goddamn intellectual property law and asset protection, which happens to be protection for that ass. Look, if common law trademark extends only to the geographical area in which it expands, then if you use the internet, you've expanded globally. You use the internet, it acts as a bullhorn, and you've expanded globally. So within the United States, do you cover all 50 states and its territories, enclaves, and such other, whatever you want to call that landmass? Of course it does. Period. Moving on. It's going to talk about registration. I'm not going to talk about registration. Let's talk about trade secrets. A trade secret is information that is not generally known outside of the owner's organization and control, has independent economic value as a result of not being generally known, and is subject to reasonable measures to maintain its secrecy. Trade secrets are often comprised of formulas, compilations, programs, patterns, devices, methods, techniques, and processes. So when I speak, let's stop right there. When I speak on the fact of OJT, on the job training with Smooth Operational Law, what you are essentially learning is how to be a trustee, but in a certain formula, a certain type of trustee that is not generally known to the public, because if it was, then there'd be a lot of me. So there are things that Smooth Operational Law does within its trust, outside of law, outside of any type of litigation. It's just the way that we handle intellectual property, create intellectual property. The way that we think about it, our sources and methods are a trade secret. The same way that, for example, the recipe of Coca-Cola is one of the most well-known examples, but businesses of any size can own valuable trade secrets. What does that mean? Listen, Coca-Cola's recipe is a trade secret. Do you drink Coca-Cola? Yes. Is it everywhere? Yes. Is it a product? Yes. Can people hold Coca-Cola and its product in it? Yes. But the know-how and the composition of how you get to that product is the trade secret. And that's what I don't put in these videos. Why am I having this conversation with you guys today? Because I've been having a lot of questions about trusts and trademarks with people who, just talking about stuff. And I really can't answer all of their questions because it would compromise the trade secret. But with the publicly available products, such as this website, it can show you what a Coca-Cola can or a trademark, or a Smooth Operational Law type of product in place of that Coca-Cola can exist as. Well, today, all we talked about was the fact that you can put trademarks, trade secrets into a trust for estate planning. When you have that mark inside of that trust, the trust can survive you, and that mark can be passed on to your children. They can then control the market. That is true wealth. True wealth in the form of intellectual property. Your children's children can inherit an empire commercially because you were smart enough or got smart enough to create an intangible property made by your intellect, which intellectual property is just making intellect your property. Oh yeah, it's that simple. And you can change the way that you view the world. Because after all, if we are just human bodies, but our souls are our consciousness in our brain, and that is the deposit of the Creator, our ability to be aware, our awareness of our awareness, our empathy, our ability to market to people on the open market. We can even program people to recognize our marks with jingles. Example, if I say pa-da-pa-pa-pa, you're going to finish it and say, this is an example, you're going to say in your brain, whether it comes out of your mouth, your ass is going to say, I'm loving it. And then you're going to think of a burger, period, and fries, and maybe even the last meal from the specific company it comes from. Intellectual property is very powerful. and to be able to put that into a trust and protect it and have trustees who can manage it, expand it into diversified markets, protect it even against a sovereign. That means that your efforts, your current, which equals currency, is even protected against the state, and they agree. Every transaction that comes from that mark is yours for the owning. Everything that results, unless you give them licenses or agreements to use, where they are indemnified from touching that preclusory asset. A lot of people don't understand that if you can protect your emissions and stop people from omitting the fact that they are obligated under the scope of the law, including agents and agencies, because there's a social compact under that law and Supreme Court case which adjudicated that they are subject. Once you get that power to understand that, you are no longer just shackled in this three-dimensional reality. You can transcend. You can be omnipotent even. And what I mean by omnipotent means is that your symbol, your mark, can be everywhere, all over the place. Through the internet, bullhorn, on a product, on the side of a road somewhere. And it's there and in full force and effect. That item is representing your source of greatness and production. Intellectual property is an asset. Put the shit in an irrevocable trust. Manage it. And your management will then handle everything that a man can get. All right, guys. That's all. It was just, I just wanted to do a little bit of a, an awareness conversation. This is what smooth operational law is about. Okay? I just wanted to give the public almost like a wake up, if that makes sense. Without all the law, without all the Title 15 this and Lanham Act that and arbitration this and contract that, I wanted to give you guys just an awareness. Putting your intellectual property in a trust, even if you put that in a generic sentence. I'm putting my property as intellect into a trust. Into a trust. Something into a vessel that you trust. That's the God power. That's the God power. Okay, guys? That's a creativity. That's your creation. You know, for all you biblical guys out there, I'm going to sound like one of these lunatics, but these legal lunatics that talk all this spiritual crap. I'm not into all that spiritual crap, just so you know. But let's just have this conversation. But if you think about it, and the only reason why I'm talking about this is because the law acknowledges it. The law, this constructive law system, acknowledges this intangible spiritualness in the form of intellectual property. So think about it. But, you know, the God power is your ability to create. It's that intangible place, your consciousness, where it allows you to create. And then you can put that into this medium, this three-dimensional reality, in the form of a marking. And that mark holds so many legal implications and liabilities. You can have people and their whole fucking life just jammed up because they infringed on that. It's crazy. But the law acknowledges it. The law even codifies it. Like, here's your code of conduct. Respect that man's creativity as it is acknowledged, coming from a specific source. It's almost like the last name of your family can precede you before you get to a location. Like, oh, your last name is De Leon? Do you come from the De Leons of this area? You guys make warriors. Whole fucking family just recognized. Do you see what I'm saying? Like Like, I don't care what language you speak. You go to 99% of these countries and you say, I'm going to go to buy me a pair of Nikes. Choose your language. You're going to say it in English. I'm going to buy me a pair of Nikes. From China to Japan to fucking Malaysia to goddamn Somalia to freaking Haiti to goddamn Canada, all the way back down to Tibet, cross off at an angle in Mongolia, do a backflip with your ass up to Sudan. They know what the hell Nike is. So we got to start thinking bigger, better. Intellectual property in a trust with people you can trust. That you can pass on to your children, your idea, and they can benefit from that. And you can leave a legacy with a team who believes in your mission to brand out. All right, guys, that's the end of my video. Great conversation. Very unorthodox conversation. Y'all have a good day. Oh, and hey guys, last thing, like, subscribe, share, comment, okay? And here's the other thing too. I want a lot of you guys to subscribe to the channel. I'm getting views, but subscribe and hit that notification bell. Like, I know it's stupid that everybody says to do it, but it really, I mean, Facebook sometimes does not allow for me to share my videos. They don't, because, and it's just because, they don't want me spamming because I send so many links out. So that way you can just get the videos. I don't release so many throughout the year, but call me up, hit me up. Try to figure out this trade secret. Call me up, hit me up, but subscribe, like, share, hit the notification bell. Okay, guys? And that's all.